there,
Okay.
Professor
Okay.
Jedini. And
Okay.
the participants came from South Africa and North Africa also. Also, some of the participants come from Italy, from your students, I think.
Ah, good. Yeah. If you want
Yeah.
to my email
Yeah.
to receive after the lecture possible requests of clarifications, comments. My email is
Yeah.
minuscule Ghidini at, then again Ghidini hyphen associati ASSOCIATI.it. IT is Italy, of course. Associati is the address of my law office, associates, etc. Ghidini at Ghidini hyphen, not
Yeah.
underscore, hyphen,
Yeah.
associati, ASSOCIATI.it. Please feel
Yeah.
free to anyone who's listening to write to me, and in due time I will reply. Also, Professor Ulak, feel free, if you believe it might be of interest, to register my lecture this morning. Feel free. It's open.
Thank you very much.
I believe in openness.
Thank you very much, Professor Gustavo Jedini. Much appreciate for your all of support for our young learners.
Thank you for the invitation. I'm really honored to be invited by outstanding universities of your great country. Thank you, Maya. Shukran. Tell me when I should begin. I think you have. You said you will introduce.
Yeah, I will introduce you first, and then give 2 minutes more while on at 16:30 we will start up our public lectures.
We can start.
Okay.
Recording in progress.
Yeah. Okay. Thank you very much. First of all, I would like to deep gratitude to Professor Gustavo Jedini, who are willing to share his knowledge, his wisdom, in understanding the very, very topical and very actual issues related to the artificial intelligence in our social life, particularly in educations, and more specifically in law of intellectual property and private law issues. Distinguished college scholars, innovators, inventors, and all of the guardians of justice, I do really appreciate for all of your willingness also to join in our very distinguished public lectures from Professor Gustavo Jedini. He is one of international leading scholars in intellectual property, copyright, and artificial intelligence. Actually, Professor Gustavo Jedini is my past colleague, almost 21 years ago. We meet in Utrecht, Professor Gustavo Jedini, when we have a program in a trip Utrecht University with Professor Willem Grosseid. And I still remember with your role, your influence at that time in all of the academic forum. And now we meet again in last August in Copenhagen in Denmark. Then you spark the ideas how to create the learning resource for all. And I do really appreciate and to support and respond all of your ideas when we meet in Denmark. Then this is now we already start the ideas. First of all, I would like to introduce to all of the audience that why we try to visualize the importance of regulatory models of intellectual property and regulatory model of artificial intelligence in the context of intellectual property and private law. This is a very, very important because we stand at the threshold of a transformations, unprecedented in human history, our civilizations. Now artificial intelligence is no longer a distant possibility. It is the beating heart of our economy, our creativity, our decision-making process, and our legal reality. AI or artificial intelligence is not merely a tool of, it is a producer, a negotiator, a decision maker, and more importantly, to co-author of our future. This is very spectrum and very important role and impact of artificial intelligence in our civilizations. So that's why we need to know about the appropriate regulatory model in order to use and to optimize the artificial intelligence, in order to appreciate and to appraise the human dignity, not to exploit and to posit the human being as an object of artificial intelligence. So in discussing about the artificial intelligence, it will expand many, many issues, not only in legal aspect, but also in ethical aspect. So we have to go into the philosophical issues, how to find the foundational issues in artificial intelligence. In order to be dedicated to support, to appraise, and to respect the human dignity in our social system. Now, together with me, we have already Professor Gustavo Giardini. That he is I have already said that he is an international leading experts in intellectual property and artificial intelligence. Will elaborate all of the issues, legal issues related to the artificial intelligence in the context of intellectual property and private law issues. Now, Professor Gustavo Giardini, it is your time. Thank you.
Again, many thanks, shukran, to all of you for this invitation, by which I'm deeply honored. I wish that this be a conversation from here to future times. I gave Professor Ulak my email address, and please, everyone, feel free to write me for possible questions, any clarifications or comments. And also, please, Professor Ulak, again, I repeat, feel free. If you think it useful, to register my conversation. It's completely open. My lecture will be divided into two parts. The first part will focus on the European Artificial Intelligence Act, so-called AI Act of 2024, and the regulatory framework, the other European regulations that compose the so-called digital package of body of law that European Union has devoted to the digital matters. The second part will specifically address the issue of intellectual property rights, in particularly copyright, but also patents, and in particular the protections, limitations, and conditions of protection of data used or produced by artificial intelligence systems, especially the most advanced, the generative ones. I hope my reflection might interest, even for some reflections, you will find maybe some motive, I hope, of interest for your own regulation, present interpretation of present regulation, and future possible reforms. I hope it will be of some utility. Coming to the first part, it's almost superfluous, usually, to mention that the world has entered a new disruptive industrial revolution, in which young people especially are the first players and protagonists. A revolution based on digital technologies and driven by artificial intelligence. Their enormous impact on almost all times of entrepreneurial, social, scientific, individual behaviors is there to increase. It is an overall impact that has great advantages and opportunities for humanity, science, medicine, but also great risks for people, culture, economy, and freedom. To address this historical change, since 2016, the European Union has developed a series of regulations, that is, legislative acts which, unlike directives who require a further legislation by each member state, regulations are self-executing in the member states. This body of law is commonly referred, as I hinted, as digital package. The most important ones to which I refer today, and to the extent that they are relevant for our lecture today, are the Privacy Regulation Protection, GDPR, of 2016, entered in force in 2018, the Digital Markets Act, Digital Markets Act of 2022, devoted to, I will furtherly give an information, identification and accountability of digital platforms, particularly the big one, the big techs, the big platforms. Then the Digital Services Act 2022, which is of interest especially for us, for its contrast to disinformation at large. And lastly, as I said, of course, the AI Act, which is aimed at guaranteeing citizens' safe use of artificial intelligence applications against the risks posed by artificial intelligence systems, as well devoted to encouraging research and development of AI technology, including protection of intellectual property rights in its results. The AI Act is the most recent, as I say, dating from 2024. And it must be understood in functional link with the regulations I mentioned, DMA and DSA, Digital Markets Act and Digital Services Act. Since it concerns protection against information and the exercise of intellectual right with respect of to data produced and used by AI systems. This body of law is firstly and foremost to be understood on a political, geopolitical, and institutional level as an expression of European digital sovereignty, a geopolitical value that Europe defends with respect to other continental systems, such as, for instance, the systems of United States, which on digital technology is inspired, as I will more deeply refer below, by an open and openly anti-European, non-regulatory policy of the current administration. Whereas the other big player, international level, the People's Republic of China, although oriented also towards social control, is closer to the European approach, being sensitive to issues of data protection, transparency, and risks of disinformation. For example, since September 1st, China has required that all AI-generated content be labeled and transparent, labeled as such, so to allow users to distinguish between the answer of a robot or the answer of a human person. And this also is useful for prevention of deep fakes. Coming to the AI Act, the European legislator has adopted a risk-based approach, responding to the concerns of social, political, and academic circles. This approach, based on risks, as I will detail, aims at building a framework of trust and therefore also an incentivizing promotional environment for the use of AI technologies by companies, public bodies, civil associations, and individual citizens. It also encourages in terms of research and development, including the reiterated protection of intellectual property rights involved in AI operations. Let's turn to the first aspect, the basic risk approach. The AI Act addresses three fundamental aspects of the overall risks posed by artificial intelligence systems. Possible damage to the safety and health of citizens, both physical and psychological, manipulation, the spread of disinformation in the broadest sense, as I will detail. C, authoritarian surveillance and other forms of invasive control of citizens. These are the main worries of AI Act. So, therefore, for instance, the Act prohibits, without exception, the development and marketing of artificial intelligence systems that pose the risk of manipulation of people's consciousness and behaviors. It also introduces information, supervision, and risk management obligations in relation to uses of artificial intelligence that involves a high risk of discrimination. For instance, in relation to the recruitment of our employees or the selections of individuals vis-à-vis the creditworthiness. Whereas the Act is more lenient, more tolerant, with applications that involve low risks that can be neutralized by providing information. For instance, in healthcare medical consultation systems, it must be clear that you are speaking, that you individual are speaking, or you are communicating with the individual physical doctor, person, or a robot. In this general perspective, and for what interests more our talk today, the AI Act includes specific reference to the tools and profiles of alteration of information, manipulations that AI makes it furtherly possible, like for deep fakes, the theft of your image, voice manipulating. And on the other hand, promotes the adoption of systems that enhance and support transparency of robotic versus human communication, like Article 5, specifically paragraph 4, and as for deepfakes, Article 360. This legislation applies to operators of artificial intelligence in the broad definition of Article 2 of the Act, including suppliers, distributors, and importers. Therefore, it applies not only to big platforms, but big platforms under the Digital Markets Act, but also to small and medium enterprises. AI Act applies also to small and enterprise. This set of regulation was destined, was foreseen, was programmed to be completed with a proposal of 2023 for a directive of civil liability for damages caused by artificial intelligence applications. It was liability, extra-contractual liability for negligence or willful misconduct, or by default, strict liability according to the general civil law model of products liability, producers liability. Unfortunately, the proposal has been since a year postponed indefinitely. However, the general principle of products liability should apply. But, of course, this is this is bad. Symptom of a sort of regulatory correction, of which I will speak a bit just a few minutes after, that European Union is undergoing in this moment, historical moment, under the pressure of some industrial circles and under the big pressure of the US administration. Tomorrow, save the date, November 19th, is the most likely date of a new document of the Commission, a set of proposals called the General Omnibus, the Latin word for everything, that will detail, should detail the slowdown, postponements, and so to say, leniency approaches to the digital package. I will speak of it in a while. But let's return to the systemic framework in which AI Act could better be understood. The other components of the digital package. The first is obviously the regulation on data protection. 2016 entered in force 2018. A legislative model for the protection of citizen privacy. The People Republic of China has largely followed, it's been largely inspired in its own regulation to this GDPR. The functional link with Artificial Intelligence Act is particularly evident with regard to the various AI systems for biometric identification, including remote identification carried out without the consent of the identified citizens. The other two regulations, as mentioned, are the Digital Markets Act 2022 and also 2022, the Digital Services Act. The functional and systemic relationship between AI Act and Digital Markets Act is of particular interest. Even though, as I said, the AI Act is applicable also to all digital operators, including small and medium enterprises, it's clear to everyone that AI Act sector is dominated by an elite, so to say, of large platforms, creating now a strong oligopoly. The strong oligopoly of the new Seven Sisters that were a century ago and less and more, the Seven Sisters of oil. Now OpenAI belongs to Microsoft. Gemini belongs to Google. Meta AI obviously belongs to Meta, Zuckerberg Group. Now, the Digital Markets Act imposes a series of specific obligations on these big AI platforms in terms of duties of self-identification openly of a structure. An annoyed US big tech company spoke of censorship. And there is indeed some excessive bureaucratic burdens, but it's right to identify, to know to whom the greatest concerns will be addressed in order to make them accountable. So these big providers should certify, both in terms of turnover or financial share value, and in terms of significant impact on the internal European market. So in terms of competitive power. They must to be considered and acknowledged as so-called gatekeepers, big platforms, gatekeepers of information, and be subject to the DMA. They must enjoy an established and lasting position in their activities, enjoy a legal presumption, so to say, legal presumption, to be acquired this power in the future. In essence, all web giants can be defined as gatekeepers and are therefore subject to this European regulation. Among the various operational obligations, I can mention the obligation to refrain from imposing discriminations and or obstacles on the activities of financial users. The obligation to refrain from combining, and here is where the AI technique come into play, personal data, the prohibition to combine personal data acquired legally with the user consent, so legally, lawfully, through the services of these platforms, legally acquired, with other data extracted without authorization of a citizen through access to other services of their own or from third-party sources. To combine data lawfully means with the consent of a citizen with other data extracted without the consent of the citizen. This combination to create a data set which includes data, repeat, extracted without the consent of the owner is prohibited. This is very important. Other obligations connected to the rank of these big platforms, gatekeepers, are those to provide organization capability to monitor and intervene and to remove contents upon orders issued either national authorities or the European Commission. Finally, in this sense, this should be a certificate, so to say, self-certification, subject to control of a commission and national authorities, to be accountable and capable of being accountable, to have an organization that really allows you to respond quickly to removal orders issued by authorities and to refrain from prohibition set, as the examples made just a moment ago, by the DMA. In essence, and coming to my first remark about digital sovereignty as a political, a geopolitical, not only legal, juridical value. That's the most important. The DMA expresses the wish for a European institutional control over both the organizational structure and behavior of big tech companies, especially also in terms of competition and respect of the informational duties that build a safe and democratic society. And this also fully applies to AI system operation. As for the other fundamental act, the Digital Services Act, it identifies, for the purpose of our conversation today, what is meant by disinformation to be contrasted. This concept of disinformation ranges from intrinsically illegal content, for instance, offering prohibited products online, to furtherly to put online contents, information in broad sense, messages that may pose a threat to physical and mental health and safety. And finally, to content, which is the most problematic category, which I will argue a bit, or content that distort freedom of opinion and behavior, for instance, through incitement to hatred, violence, pornography, and various forms of discrimination based on ethnic, social, gender states, and other religious. Contents that should be, according to DSA, subject to interventions by authorities, national and European. So, in extreme synthesis, the Digital Market Act outlines, so to say, the subjective scope of the area of control of information, while the DSA defines the objective scope of a fight against disinformation. And again, so AI Act should be read in relation to particularly and more extensively to DSA, Digital SA, first of all, because it defines high risks, unacceptable AI systems, which Article 5 and 6 of the AI Act present risks of violating democratic life, the democratic mechanics of, so to say, of democratic life, elections, for instance, and human freedoms, including the freedom to enjoy one's own privacy. Risks that can materialize, especially today and in the future, unfortunately, through manipulation and deep fakes created by artificial intelligence, deep fakes defined in Article 360. And indeed, in everyone's experience, in every country's experience, more and more, artificial intelligence can be, and has often proved to be, a most powerful tool for manipulating opinions, altering, modifying reality. And these forms of manipulation, alterations, is especially the focus of AI Act in together with, in coordination with the DSA. I also believe and agree with the European Commissioner on Digital Sovereignty, Commissioner Hanna Virkkunen, a Finnish commissioner, that the EU, the European regulation, as I briefly, and of course in limits of time, evoked, is a progress. Is a progress compared to what not only me, but many others call the digital Far West, the digital regulatory Far West of the United States. Far West, where you are free to under the present administration, the US, the federal US law, places no substantial limits on the use of AI system and no substantial limits on the circulation of disinformation. This has been affirmed by top political representatives and top political and top entrepreneurial administrator of a big tech, of digital big platforms. Because a regulation inspired by those principles I evoked of respect of basic individual freedoms, respect of the mechanics of democracy, respect of physical and mental well-being of citizens is a good thing and must be preserved. This said, in my opinion, the European regulation should be amended, not only being reduced by excessive administrative burdens, of which I will speak a bit later, and which especially I remind to save the date to tomorrow, what the Commission will issue under this broad omnibus paper. But the 2 points on which I propose, I imagine, a modification of the European rules. I don't know if my remarks could be useful also for your great country, future, present and future reflection on the regulation of AI. But first, the circulation of anonymous messages and anonymous news and news from anonymous sources on the internet should be strictly prohibited. Accountability, responsibility. If you put a message, a news, you should be identified. No anonymous letters on the net. Particularly dangerous for the vast worldwide circulation of these social platforms. This measure, no anonymity, could act as a dam against the flood of messages on the web containing hate messages, discriminatory, offensive, pornographic content, as well as fake news. The second reform, which I propose, is to modify and change, reverse, the present legal provision of the DSA Act, in particularly Article 8, which does not oblige platforms, which exempts platforms from the duty to filter illegal content. To be precise, but the kind of messages that I just described before. The rules of not imposing obligation on web intermediaries was justified in the world and era of analog communications, where, for instance, example, the example was the classic one, was the telephone company would not be responsible for indecent conversations between two people calling on the telephone, of course. But now in the era of platforms and AI, this is no longer justified. No longer justified in an era where our AI tools themselves can be used to monitor and filter illegal content, such as hate speech, discriminatory requests, pornographic content, and so on. This is possible now, technically. Zuckerberg offered this service on payment. Now he's retreating, saying no fact-checking, no. But it's possible. So if it is possible, it should be mandatory. With these two personal recommendations, which I submit to your attention, even for Indonesian regulation, maybe in the future or now in the application, I don't know. I hope it will be useful. I still, repeat, prefer the EU regulatory model. I prefer it vis-a-vis the absolute almost absolute anarchy that the United States currently allows in the field of digital communications. As I said, high level, even highest level, political and institutional representatives and the chiefs of a big ruling platforms, dominant platforms, openly, expressly reject the idea of a regulation that would place limits on what can circulate online. What is their argument, one may ask? Their argument is freedom of expression, the sacred principle. I'm not ironizing. A sacred principle granted in US by the First Amendment to the Constitution. In our law, by article, in our Italian constitutional law, by the Constitution, Article 21, and by the Charter of European fundamental rights. But this sacred principle is invoked in US as a passepartout key for everything that could be considered dangerous, offensive, discriminatory, bluntly false, pornographic, etc. That justification, so broad and understood, is not only unfounded in substance, in the merit, as I will argue, but is quite self-interested, put forward by these web giants, because they earn money, make money, precisely thanks to the volume, the huge number, the volume of contacts, of connections that digital networks allow to establish. And they are therefore fiercely opposed to rules that inevitably limit that value. Because, of course, the digital economy is a network economy in which value is typically generated on the basis, as I said, of volume of connections, and where the price factor can be secondary or irrelevant, as in very frequent cases of free services offered online. In reality, these are not really free, because the price is our willingness to become targets of all kinds of advertising offers and source of data, of personal data extracted from our life in using credit cards and answering to offers, choosing movies, choosing books, etc. We are mapped on this, and we are the source of this value that is furtherly used for advertising purposes. But just for this, rules that impose limits reduce revenues, and so long live freedom. And even for the merits, it must be acknowledged, first of all, but sure, it's delicate to draw a line between freedom of expression and abuse of that expression. Here, though, common sense on the one hand and respect of fundamental citizen and social communities' rights on the other cannot fail to consider incitement to hatred, discrimination based on gender, ethnicity, religion, and whatever, violation of privacy, violation of personal rights, name, image through through the fakes, messages entering or inciting pornography as abuses. So the line can be set with precision, but can be set. This line is recognized by several European courts, by the Courts of Justice of the European Union, and from the United States Supreme Court itself. I don't know in the very next future, but in the past, there is, for instance, a famous decision of the Supreme Court of 1964 in the case of Sullivan versus New York Times. The New York Times, in an article, accused Mr. Sullivan, who was a public officer of public administration of a southern state, of discriminatory behaviors against Black citizens, Afro-American citizens. The article contained some factual inaccuracy, but the court said that since the article did not distort the overall reality of the situation, in the sense that in truth, Mr. Sullivan had done some effective behaviors in discrimination, they allowed the newspaper publication. They recognized the freedom to publish. But the limit implicit was those were minor inaccuracies that did not disturb the basic complexity truth of the situation. So messages of hatred, discrimination, pornography, violence, these are not fantasies. These are precise kind of messages that should be strictly forbidden from circulation on the net. There is no freedom for these abuses possible. The other modification that the Commission is currently trying to bring to these digital regulations, as I said, has to be ascertained tomorrow, 19 November, where the omnibus project proposals will be issued. So watch maybe on the 20th what the Commission says on the 19th. Should be expected. Maybe profiting from the different timetable, you will be able tomorrow itself to check this. From the rumors circulating as today, there is some voices, that the Commission will a bit or big bit or small bit relax the privacy regulation, allow companies, AI companies, to get more personal data, introducing new derogations that will allow AI and platforms, AI systems, to draw more personal data than they are allowed now to respect, than they are obliged now to respect. Another possible modification, but this is positive, certainly possible, to create a uniform, this can be useful model, a single unitary cyber agency instituting a single unitary system, one authority, to report cybersecurity incidents and breaches of personal data. This will be a positive step. But one other profile of is possible today, tomorrow, October 19, very now so far very secret. Even some directors of big directions of important directions of the Commission still ignore what will come up, but maybe there will be a relaxation of the present regulations on banners on cookies, to remove banners and leave more freedom, relax freedom to constrain people to receive and accept cookies, advertising messages with less restrictions. But, repeat, we must expect tomorrow. As I said at the beginning, let's now come to the second part of my lecture. The topic of the specific relationship between artificial intelligence and copyright, and also, when it's the case, patent law. In particular, the advent of artificial intelligence raises several issues related to intellectual property. The first issue concerns the protection through copyright or patents all the results, the output produced by artificial intelligence. These are products, output, that can be of artistic, informative, or also technological nature, like computer codes. The first legal action commenced in the United States in 2022 concerned the alleged illegal use of computer codes still under copyright from by intelligence, artificial intelligence operator. So the first issue is intellectual property on the products, on the output of AI systems. The second issue concerns data protected, possibly protected by third parties, protected by copyright or patents, used by robots, fed in the algorithms to produce certain results. So this is the input, data for training, so to say. A third issue, which I will rapidly hint to concentrate on the first two issues, relates to the algorithmic solution, the algorithm through which the results, the output is produced. But this doesn't pose, this issue, significant problems, because algorithms are software. What else? AI is the aristocracy of software. Therefore, as software products, they can benefit both of patent protection and copyright protection, each of which according to its own specific regulatory requirements. For instance, under the rules and the guidelines of the European Patent Office, now issued in a version of 2025, European Patent Office EPO rules on computer aided inventions, computer produced invention, and artificial event. But this is, in a way, more simple and less disputed, of course. But let's address the first issues I mentioned. The output, the result, the product put online through artificial intelligence, put online at disposal of the public. First of all, let's consider, and this should be considered, the material duality of artificial intelligence technologies. The merely servant or servient type, primarily subordinated to detailed human instructions to achieve a certain result. And the ever increasingly important generative type, which predominantly develops output on its own based working generated by human instructions, requests, prompts to achieve given results. In the European law, so far, this substantial synthesis of legislation and administrative practices, beginning from the European Patent Office, this duality is not very clearly understood and applied, because European so far is the must adverb, caution, to adopted in this unknown territory that changes borders every day. Generally, European law generally admits works produced by robot to intellectual property protection. So, in other words, doesn't clearly draw any consequence from the from this mentioned duality, even if it is evoked, this duality, by the very definition of AI provided by AI Act itself in Article 3, that says various level of autonomy. But I warn against this indifferentiated generalist approach, even in interpretative and judiciary level. Because in absence of a clearly differentiation between predominantly human and predominantly robotic output, this could lead to an exponential increase in the attribution of copyrights and patents that would impose myriads of copyrights and patents with undifferentiated and heavy access costs. This would go against the historical logic, systemic logic of intellectual property protection, which aims at protecting and incentivizing new socially useful results deriving from human ingenuity. So the attribution of ownership of intellectual property rights should correctly be in favor of a creator or assignee, enterprise, editorial, of a new and non-obvious digital work. Because under a generalist approach, the creator of the output could accumulate a software patent, as I said, on the invented algorithm, and a copyright separate patent on the output mainly generated by the robot. A bit too much, not to think. Here, an interesting suggestion, which I think should be followed even at judiciary level of application, comes, in this case, from the United States Copyright Office, that issues guidelines regarding the objective conditions for granting copyright protection, copyright registration in US, registration at the Copyright Office is important to obtain a fuller copyright protection. Now, this office has stated in its guidelines, renewed in 2025, this year, but also since 2 years ago, the office will declare non-eligible for registration works realized through artificial intelligence technology, which has received only an order, a simple prompt from a human being. And in response to this simple prompt, produces a complex written, visual, literary, musical work of any kind. In this case, the office says, I quote, "These prompts function more like an instruction, like instruction to a commissioned artist, an actor. Please make a portrait of mine based on my photography." These prompts identify what the prompt wants to be represented, but it is the machine that determines the result, the portrait, so to say. And they make an example related to poems, to poetry. If the user instructs a generative robot to write a poem in the style of William Shakespeare, the system will work and might generate a text or more than one text that resounds in the style of a Shakespeare poem. But the office says, the Copyright Office says, the technology, it is the technology that will determine the rhyme scheme, the words in each line, the structure of a text. And when it is the AI system that determines the expressive elements of its output, remember that copyright protects not the idea but the expression, then the generated material is not to be recognized as a product of a human author. Consequently, such material will not be registered in the copyright register. This position, which I personally do approve, goes beyond the scope of copyright law strictly understood, because can be adopted in the realm of technical output, so in the domain of patents, because this line of thought to be, to be applied on the basis of case by case, single concrete case by case analysis, not in general. Okay, a general principle to be applied on a case by case. I said goes behind copyright law and the interest of patent law, because in the two fields, copyright and patents, if you think, just a moment, the specific legal basis supporting this differential approach are similar. In copyright law is the absence of creative character as an expression of human personality. It is the requirement which, for example, distinguishes between an artistic photographic work from an ordinary photographic work. I put the camera in front of a monument, click, but an artistic photographic is something different. This is an object in copyright related to the recognition of authors' moral rights, protecting their cultural personality, name, and reputation. But these functions also in the field of patents, where the problem of saying yes or no to patentability relates to the presence or lack of inventive step, of non-obviousness of invention, non-obviousness vis-a-vis the knowledge of an average technician of a sector. Now, in fact, with the existing artificial intelligence systems, any average technician, expert of a field, could upload basic data for training on the latest generation of ChatGPT and give a command prompt to a certain result, even technically in the field, to produce a result that could be or could not be object of a patent. If a simple technical expert of a field prompt is enough on the basis of a prompt to produce a technical output, this technical output should not be object of a patent. You could patent the algorithmic solution that produces it, because that is always human, but not the product itself, if mainly produced by the generating algorithm activated by a simple prompt that any average technician can give. In conclusion on this issue, intellectual property rights should cover, repeat, on a case-by-case analysis basis, the results, the output of predominantly human-driven artificial intelligence system and denied to predominantly robot-generated systems. A reductionist solution, which would be consistent also with the principle of proportionality. And not only on the principle, in harmony with the principle of proportionality, proportionate to what is really the human effort, the human contribution, but also from a competition law perspective, as I hinted before, proportionate to the competitive impact of this proliferation of otherwise indeterminate flood, huge number of patents and copyrights. So this differentiation with proportionate would stimulate the development of new and useful auxiliary tools, copilots for human ingenuity, and significantly promote the containment of an otherwise uncontrollable proliferation of exclusive rights without justification on human merit. I hope this line, I really believe it, is expressly clear. Is expressed clearly. The second issue concerns, as mentioned, the intellectual property rights of third parties over the data used to train the robot, not reproduced in the output, but used to train the robot for their functioning to produce output. But this is the input. I mean, of course, data in the broad sense, writings, formulas, codes, images, music. Data which are partly provided by the human operator to train the robot, and may also partly, especially in the case of more advanced general systems, sturged after the prompt on the internet and used by the robot itself, and used cumulatively to produce the output. Now, it is well known that the technical mode of production of artificial intelligence requires very fast access and immediate use, fast and immediate, of enormous billion quantities of data. As in all systems, but in particular in the generative systems like ChatGPT, Midjourney, DeviantArt, and others, for instance, in your great country. And inevitably, while some of this huge amount of data is in the public domain, no problem. Public domain by itself, because the data protection is expired patents, expired of copyright, or the data have been put at disposition to the public by public authorities, as under a directive 1024 or 2019, a EU directive on open data and the reuse of public sector information put at disposal of the public by public authorities. But, all right, public domain apart, inevitably, other data and many other data are inevitably that this big set used by artificial intelligence system is subject to intellectual property rights of authors that are still in force. Just think, for example, of a field of visual arts, as well of literary, scientific, journalistic works, from which AI draws and uses copyright protected data to produce new artistic, literary, journalistic, scientific works. It was famous years ago that on the basis of a prompt to a robot, analyze, look, search all the, I think it was 44 existing published paintings of Rembrandt, make a portrait a la Rembrandt. And he produced the portrait of a gentleman of the 17th century, really a la Rembrandt, on the basis of a simple prompt. This would not be registered by US Copyright Office, rightly. The algorithm that produces it, yes, patented, but not the algorithm. Other examples could be computer codes developed on the basis, on the shoulders of previous programmers. As I remembered a few minutes ago, the first action brought in the United States was brought by code programmers whose codes were allegedly reproduced by AI operators in their output.
Excuse me, Professor Giridi.
Excuse me.
Yeah, excuse me.
Can you speak a bit louder?
Yeah, is it possible to open up discussions in order to concise a little bit? Because in Indonesia, we are going into the time for Salat, for prayer, half an hour more. And is it possible if we use the rest of time for discussion, open discussion?
I think that I was going to terminate my lecture in about, because this topic of the use of protected data is now the most actual topic in European law under the Copyright Directive, VA Act, and the so-called problem of text and data mining to produce the result. So, if you, I could run a bit in 10 minutes.
Okay, yeah. Yes. Hello.
I am at your disposition, of course. But it is considered now the most debated issue. What is the problem? If the data used to train the robot are covered by copyrights of previous authors, what does copyright or patent law or patent right allow? They are excludent rights, which allow to exclude, to block. It's the basis of exclusive right. Stop, refrain, if you use this data, stop. I can stop you and ask reimbursement. And these are the object of famous cases going on in US, in England, in Europe. But this would slow the fluid and current and rapid working of AI intelligence itself, which requires, as said, rapid access, rapid working, not to be stopped. And the present system of intellectual property, as also recalled in the AI Act, which makes a remand to a copyright directive that affirms the rights, the exclusive rights, is there to throw sand in the engine, as prove the several big millionaire cases, the joy of lawyers, of course, instituted in US and Europe, and the millionaire transactions which take time, waste of money. These are irrational proceedings because AI, which can produce enormous advantages for medicine, for productivity, needs to go faster. And in Europe, the freedom to extract and use is formally, theoretically allowed, but subject to two exceptions which destroy the freedom. A hypocrite system, because the freedom to extract and use for making an output, which final output should be different. Otherwise, it would be an infringement, of course. But formally, European law says, yes, you're allowed to extract, to use, but with two exceptions. The data to which you can have access for making are subject to lawful access. Well, lawful access means in every sense that you have obtained a permission to a license. And license is given not freely. And in any case, you have made a reservation, opt out, you AI operator, reservation. Excuse me, the author, the copyright owner has made a reservation against reproduction. But reproduction, reservation against reproduction is a universal, common editorial practice of professional information. In every article is reserved. So what kind of exception is this? These are fake exceptions which affirm, as the cases brought to tribunals, big cases involving stop to the use of data protected by AI. The paradigm I support for a future reform is, first of all, freedom of extracting data if you do not make an infringing output. Meaning that if you just extract data, work them, and the final product that you put on the market is different from the original works that you have used, this should be free. as it happens in the human brain. My works are the fruits of several data reminding of previous jurists. All culture lives on the shoulders of those who preceded us, provided I don't infringe the works I'm using. But this is a quantitative difference, not a in default of this freedom, not exception, this freedom to use data without, provided that the output is not infringing, the output is not reproduction, the final output, provided that we should be free. In default of freedom, another paradigm of intellectual property should be adopted, one of open paying access. Don't stop AI working. In case, make them pay. As in a highway, we call in Italy the telepass everywhere. You make an abonnement proportionate to the distance you will drive, or the size horsepower of your car. But you pay and the bar lifts. You don't stop at the bar, you proceed. So this telepath approach that would concile the need, the request of retribution with the need to proceed, of working, of AI systems without stopping, fluidly, rapidly, and efficiently. So with less costs of the administrative costs of the whole system. So, principle freedom, provided there's no infringement in the output. In default of freedom, open paying access. And this open paying access system could be well administered by collecting societies, which can use the very also tools of artificial intelligence to distinguish, for instance, from the use of 50 lines from the top journal, the top magazine, the top daily paper, and 50 lines from a small provincial paper. Why not? But don't stop the fluidity of flow. Raise the bar. I took my 10 minutes. I thank you very much for your attention. I can't hear you.
Yeah, thank you.
Okay. May I ask to speak a bit louder?
Yes.
Because,
yeah.
Okay.
Okay. I will. I will. Now, can you hear me?
Yes, I do.
Thank you. Again, thank you very much for all of your very passionate and detailed elaborations on the European Union AI Act, also the battle of the EU AI Act that are under pressure of the industrials, as well as the detail. You come into the detail between copyright and artificial intelligence. You touch also about the issues on the incompatibility of the copyright protections to the AI generated products due to the conflict, not human being products. And again, thank you for everything that you have already given to us.
I hope I was clear. I always hope my main goal is not to be approved by what I say, to be understood.
Yeah, that's right. That's right. There are many questions now, and I would like to invite Dr. Anwar Fahri. Dr. Anwar Fahri, did you hear me about this? Hello, Pak Anwar Fahri. Yeah. If he does, I would like to. If he already passed, I would like to read his questions to you, Professor Gustavo Giddini. Yeah, he wrote in the chat of this his questions. Hello, Pak Anwar Fahri. I try to search in the chats. Yeah. Also, there is a question. One question also from Dr. Jamal from Parahyangan University from Bandung. First questions, respected Professor Giddini. I am Anwar Fahri from the University of Mataram. Allow me to offer two humble questions from a small corner in Lombok. One, how can we or Indonesia craft an adaptive artificial intelligence regulatory model framework, learning from the US and EU models without becoming technologically dependent while we are still fostering our local innovation? That's one question. And the second question is, in an era of generative AI, how should in an era of generative AI, generative artificial intelligence, how should Indonesia rethink copyright and patent rules to balance innovations, fair access to data, and the preventions of market monopolies? Yeah. And one question, I invite Professor Jamal from University of Parahyangan to raise questions to Professor Gustavo Giddini. Please, Professor Jamal.
Okay, thank you, Bob. Nice to see you, Professor Giddini.
Good morning.
Good morning. Good evening in Indonesia.
Sabah al-Khir.
Okay, I have one question. As I know, the EU AI Act also regulates ethics. Could you please give example of such ethics, considering that European Union countries of several countries with different cultures? On the other hand, if there are cultures difference that lead to disputes,
Lead to
what?
Lead to dispute.
Lead to dispute.
Yeah. About ethics. Dispute about ethics.
Ethics. Yes. Okay.
Yeah. Okay. Where do they resolve the problem?
Yes.
Thank you.
Okay.
Wonderful. Prof. Jamal, thank you very much.
Let me try to answer in this session.
Yeah,
how can
please.
In Indonesia a regulatory framework being established? First of all, I think the political point, which is really political point, your great country sovereignty on this. That is to feel and want to be the independent authors in the world scenario of a regulatory framework which is consistent, and here comes partly political, cultural, and partly, of course, in the instrument, legal, coherent in your autonomy, in this sovereignty, to your constitutional values, to the spirit of our constitutionally ranking values, as expressed in your general principles, in the general principles of your law. So you treasure what are the principles that in your constitutional and culture you want to be at the center of the regulation, independently from pressures of any kind, especially big pressures. Independently from pressures of any kind, you make the core values, constitutional, ethics, social value, social ethic, that you want to be at the core of your regulation. After this, you look around and, for instance, study the models, the normative models of EU law, which in the main principles, I think, is largely inspired to share values of your culture, respect of individuals, respect of decency, no discrimination, and see whenever you find a coincidence of value, you study how, in legal technical terms, the EU has outlined these principles. Maybe avoiding some excessive administrative burdens that could embarrass, block the innovative capacity of small and medium and how they are called, startups companies, usually young people work. Look at how technically the values you find coincidence when you will have maybe others from Islamic culture, which is a great culture. But you put at the center of your reflection and see in which way core principles of culture, respect of human values, obstacle to pornography, etc., are legally, in technical legal terms, carried on in the European model, but also give a look to the Chinese model, not to make a xerocopy, but to look at some important innovations that the legal order of People's Republic of China has introduced, especially in the field, in the area of transparency, recognition of what is robotic and what is human in the communication. This is very important. Then you should, I think, follow, as we come to the relationship with the world of IP, follow the guideline whereby what is the product of what is predominantly product of human instructions, of human inputs, can be protected, whereas what is predominantly made by impulse of simple prompts, these outputs should not be protected. We speak of the output, the final output. Because what is predominantly made by the robot is not by itself per se produced on human merits, on predominant human merits. What is predominant human merits is the algorithmic system which produces the output. It can be object of a patent, of a software patent or a software copyright, but not the output. Then, as concerns the need, the operational need of a technical mode of production of artificial intelligence, which, different from the analog world of yesterday and in part of some industries of today, needs to absorb, gather, and work immediately, as fast as possible, and to work as fast as possible new useful results. This mode of production must not be embarrassed, stopped, slowed down by someone who said, oh, this is mine, protected by copyright, hands off, stop, pay me, and make a suit, legal proceedings. I hope that not too many practicing lawyers hear me, because they, I'm joking, of course. This proves negative for the rational and typical mode of production of AI results, which can be very helpful, very innovative, very useful, and should not be slowed down. So, the first and in default approach to the use, extraction, not reproduction in the output, which is infringement, of data protected by copyrights or patents still in force should be, first of all, my suggestion, leave this operation of extract, not followed by infringing result, free, in principle. Like it happens in your own mind of scholars who have absorbed lots of things and they are reworking in your mind. And this is the way that culture proceeds. How much art, contemporary or art, has been developed in the centuries based on going on the shoulder of prior art. Picasso used to say that artists copy, the genius, he was thinking of himself, steal. And think how many works of the so-called Cubism period of pictorial works were based on previous work by Picasso and others. Why should not be, if the output is different, in the same style, inspired by? But style is not protected by copyright. Copyright protects the counterfeiting, the plagiarism of the final output put in competition of yours on the market. If this counterfeiting, total or partial, does not exist, you free use. But if you, in the dialectic between industry, authors guild, AI operators, will, in the debate, in the social, political, legal debate, be refused and be affirmed the principle that since you gain something from the use of the extraction of my works, you have to pay. In principle, this should not be, because the only prohibition should be infringing output. But if this logic of compensation prevails, make it a non-excludent logic. Make it a telepath logic. Pay, but no bar. The bar lifts it. You continue to go, to run. This is my recommendation. As to ethics, I return to my first suggestion. And the principle of sovereignty. You are the sovereign of the ethics and constitutional principles that you should put into your regulation. While technically made confrontations with Europe or in part with China, but that will be a technical way of translating principles into your own law. Your principles, your priority of principles, priority of principle. Not all constitutional principles are born equal. There is a hierarchy. For instance, the freedom of enterprise is a constitutional principle. But with freedom of enterprise must respect the fundamental rights of the individual, cannot go and be exercised in prejudice of social utility according to your moral and constitutional framework, or in a way, however, to damage health, freedom, and dignity of individuals. Those values come up in the scale of constitutional values. This is important.
Yeah, this is very fascinating answers, Professor Gustavo Giardini. I do really impressed with your points that remind me about the Ronald Dworkin concept. If we found that there are 2 or 3 principles, we have to make a gradations of the principles in order to make a hierarchy. Which one is
exactly.
Yeah. That's a very fascinating answer. Then it means that all of the highest, the constitutional principles that exist and stipulated under constitutions, all of them must be subsumed into the hierarchy. Yeah,
Absolutely.
in order to find out which one is the highest values.
Absolutely.
Thank you very much. Thank you very much, Professor Gustavo.
If there will be other occasions in the future, I will just be glad, because you are a great culture. I am only too old to make such long journey of 18 hours.
I hope one day.
Let me step by step.
Yeah. I understand. But I know I'm still fresh in my memories about your very highly performance when we met 21 years ago.
I was younger then.
Yeah. And now I would like to invite maybe from a room from Italy, Fabrizio Benedetta. You have any questions?
Please, let's a bit, because I'm very tired.
Oh, yeah. Okay. I think it is time.
Oh, it's okay.
If there is no questions from others, then I think we have already discussed in 2 hours. That's really impressed. I do really thanks, deep gratitude to all of your detailed informations, detailed answers, and fascinating solutions that we can absorb in order to nurturing and constructing the public policy in regulating the artificial intelligence in Indonesia.
I am at full disposal of yours if in the course of the development of your legislation you would like to share some opinion. I will be just happy.
Alhamdulillah. Thank you very much. Thank you very much, Professor Gustavo Giardini.
Thank you.
Again, thank you very much for everything that you have given to us. And again, all of the participants, is it possible you open up your camera and then before we close, we make documentations, Professor Gustavo Giardini? Documentations to together, make a picture, photograph. Mas Galih, bisa diaktifkan? Dokumentasi, Mas Galih? Halo?
Aman, Prof.
Ya, bisa di ambil kitab, kenang-kenangan, dokumentasi pertemuan Global Post Academic yang pertama kita. Sama semua. Bisa di cover Mas Galih?
Okay, wait for a moment.
We will take a big picture and then afterwards we close.
Thank you.
Kasih aba-aba Mas Galih. Mas Galih? Yuk. Admin, ya. Aktifkan dia. Ya. Mas Galih, oke?
Oke, bro.
Ya, kasih aba-aba Mas.
Oke, 1, 2, 3. Wait.
Thank you. Sudah Mas Galih?
Once again.
One more. We will take a picture together, Professor Gustavo Jedini.
Yeah.
Okay, last one. 1, 2, 3.
Thank you.
Okay,
Sudah?
thank you again.
Ya, terima kasih. Okay, again, my deep gratitude on behalf of Indonesian PhD Councils, University of Mataram, University of 11 Maret, as well as University of Islam Indonesia and associations of lecturers and researchers of Indonesian intellectual property. I do really express my deep gratitude to you for all of your passionate and inspiring public lectures, Professor Gustavo Jedini.
I am honored and I thank you. Shukran,
very
and
much.
I am happy that it was foreseen before, but I had a problem and then we could make it. Alhamdulillah.
Recording
Alhamdulillah.
stopped.
Thank you very much. Thank you very much.
My few
Assalamualaikum.
words.
Then I will return back to komite. Galih, ada hal-hal yang mau disampaikan berkaitan dengan pensertifikatan. Sudah sih dikasih tanda tangan Profesor Gustavo Jedini juga untuk sertifikat yang akan ditandatangani.
Baik, mungkin bisa menunggu untuk sertifikatnya akan diproses.
Oh iya. Nanti akan diberikan langsung ya ke masing-masing peserta di emailnya masing-masing. Baik, sekali lagi saya ucapkan terima kasih banyak atas segala semangat, kehadiran, perhatian, dan support dari seluruh peserta yang betul-betul memberikan support di dalam kegiatan diskusi kita bersama tentang artificial intelligence yang sangat topikal ini. Insya Allah akan kita lanjutkan pada edisi berikutnya. Insya Allah saya akan umumkan lagi melalui komite dari Global Post Academic Program. Wassalamualaikum warahmatullahi wabarakatuh.
Assalamualaikum.
Thank you, Pak.
Thank you.
Thank you.
Izin live ya, makasih.
Ya, izin live.
Good night.
Terima kasih.
Makasih Prof. Hak.
Makasih. Terima kasih Prof. Budiman. Alhamdulillah, senang sekali nih Prof. Budiman kita jumpa lagi di sini.
Ya, terima kasih ya.
Terima kasih Prof. Hak. Pak Budiman, apa kabar?
Terima kasih
Baik.
Prof. Jamal.
Mantap Pak Jamal tadi.
Amazing, ini sudah terjawab persoalan yang didebatkan sama Prof. Jamal di email kita ya. WA APHKI.
Iya, betul. Dapat poinnya keren ya Prof. Hak ya.
Alhamdulillah, langsung dari datuknya ini kan.
Oh iya, keren jawabannya. Kapan itu bisa terjadi di Indonesia ya?
Ya, kita akan diskusikan, kita siapkan langsung dari APHKI lah. Bagaimana
Ya.
Prof?
Mantap. Lanjut.
Terima kasih. Assalamualaikum warahmatullahi wabarakatuh.
Terima kasih, Pak.
Ya, makasih. Makasih Pak Nyoman. Vena Res Tequila. From where? Indonesia or Italy?
Ya,
Mbak Vena dari mana?
Indonesia.
Medan kayaknya ya. Tapi ada tequila itu.
Palangkaraya.
Alhamdulillah. Terima kasih.
Tequilanya boleh kirim-kirim itu Prof. Hak.
Ya. Alhamdulillah bagus sekali awal yang baik ini saya kira. Terima kasih ya Prof Jamal ya atas
Terima kasih.
kehadiran dan supportnya.
Assalamualaikum semua. Salam
Waalaikumsalam
sejahtera buat
warahmatullahi
semua.